Call to order this regular meeting of the Lincoln-Lancaster County Planning Commission of June 26, 2019. A printed agenda is available outside the hearing room, and a copy of the full agenda, including the staff reports, is available at the front of the chambers with the clerk. The Open Meetings Act is posted just inside the doors at the back of the room. If you parked in the parking garage across the street to the north, the gate is open and no parking coupons are needed. Out of courtesy for those attending this meeting, the commissioners and the staff, cellular phone usage is not permitted in these chambers during any portion of this meeting. We will appreciate your cooperation. The first item of business is the approval of the minutes of the regular meeting held on June the 12th, 2019. Is there a motion?
Move approval, Core.
Second, Finnegan.
Please call the roll.
Beckius?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Joy?
Yes.
Core?
Yes.
Scheer?
Yes.
Motion carried 6-0.
We now have a couple special presentations recognizing Commissioner Harris and former Commissioner Washington. First, Maya, could you go to the front of the podium, please? I would ask Jerry to read the resolution of appreciation for Commissioner Harris.
Okay. Planning Commission Resolution Number PC-01658, whereas Maya Vicklins Harris was appointed to the City of Lincoln, Lancaster County Planning Commission on November 18th, 2013, to fill an unexpired term and has resigned to pursue new opportunities involving an out-of-state relocation. Ms. Harris has contributed over 5 years of volunteer service to Lincoln and Lancaster County community as a member of the Lincoln-Lancaster County Planning Commission. And whereas during her years of service, Ms. Harris contributed countless hours and diligent effort toward the adoption of periodic updates to the Lincoln-Lancaster County Comprehensive Plan and Long-Range Transportation Plan, updates to the county and city zoning codes, and has reviewed over 1,088 development applications. Other projects and studies of major importance which came before the Planning Commission during her term include, but are not limited to, the 2018 Downtown Master Plan, Transit Development Plan, West Haymarket Arena redevelopment, commercial design standards and new parking standards, long-range transportation plan update, and comprehensive plan updates. Outdoor lighting standards update, large-scale wind energy projects, streamlining the process for subdivisions and waivers of design standards, and review of various watershed master plans and redevelopment plans. South Haymarket Neighborhood Plan, Lincoln Bike Plan, annexation packages, accessory dwelling units, review of proposals as a member of the Board of Zoning Appeals, and capital improvement program conformity reviews. And whereas the growth and development of Lincoln and Lancaster County has benefited greatly from the years of dedicated service of Ms. Harris. And whereas in recognition of over 5 years of loyal and dedicated service, it is the desire of the Lincoln-Lancaster County Planning Commission to express their appreciation and gratitude and to commend Maya Harris for her dedicated volunteer service, and to cause such expression of appreciation and gratitude to forever be made a part of the official records of the Planning Commission of the City of Lincoln, Lancaster County. Now therefore be it resolved by the City of Lincoln, Lancaster County Planning Commission that the appreciation and gratitude of all are hereby extended to Maya Vicklins Harris in recognition of her dedicated service, support, and contributions to the public planning process for the City of Lincoln and Lancaster County, dated this 26th day of June, 2019. And it's signed by your Planning Commission members.
We'll entertain a motion.
Oh,
So moved, Joy.
Second, Finnegan.
Okay, discussion, anything anybody wants to say to Maya?
Thank you very much for your years of service to the city of Lincoln. It has been a joy working with you, and we wish you the best on your new adventure.
Others?
I've learned a lot from you, watching you and listening to you as you perform your duties, and I've enjoyed working with you, and I'll miss losing a Harris.
And thank you. I've learned a ton from you, and your leadership has been excellent on the board, so thank you so much.
I've learned a lot from you too, and I appreciate your perspective. It's incredibly professional and broad, and especially on those really hard decisions we had to make. We've had a few since your term started, and just fabulous commissioner. Thank you very much.
Thank you.
Okay, I'll now ask Steve Hendrickson, representing the Planning Department, to present the plaque to Maya.
Sure. We have a plaque here thanking of Maya and honoring her for her years of service. For 6 years, Maya has definitely kept staff on our toes with her questions, always very well thought out questions, looking into the intricacies of zoning that we don't often see. But we've really appreciated that she's always trying to keep the bigger picture in mind, and the fact that we know that Maya is going to be looking into all of the details has made sure that we try to craft our staff reports as carefully and as clearly as possible. And so we have really appreciated that. And we know that her interests have gone from everything from accessory dwelling units to alcohol sales. And I only mean that, of course, in a planning sense. It has just been really a great joy for us. So certainly we honor you for all of what you have done. And sadly, you're not just leaving the Planning Commission, but Nebraska as well. But we wish you all the best in your new adventure. And again, thank you for your years of service. So hope everyone can join me in thanking her for her service.
Just like to say thank you. I've so enjoyed working with you and some of our former colleagues who are now contributing in other ways on other boards. And I feel really fortunate to have gotten to learn from two fabulous planning directors, Marvin Kraut and David Carey. David Carey's not here today, but he sent me a really nice email. And it's been so fun to see all the young people coming into the planning department and becoming, I'm so impressed by their professionalism and their ideas. And I've certainly been the beneficiary of learning from some of the people here today, Steve and Brian, and the list is too long, but it's just been amazing to have. I love to learn, and this is an awesome learning opportunity. So anyone who gets to serve on this commission knows that you get to learn from everything under the sun. So it's been so fun. I'm gonna miss you guys.
Thank you.
We do have a motion on the floor to approve the appreciation, or resolution of appreciation for Maya Harris.
I think we're ready to vote.
Okay, Beck, yes?
Yes.
Finnegan?
Yes.
Joy?
Yes.
Core?
Yes.
Shear?
Yes.
Motion carried, 5-0.
Okay, next, Sandra, could you come forward? So I would ask Jerry to read the resolution of appreciation for former commissioner and now city councilperson, Washington.
Okay. Planning Commission Resolution Number PC-01659. Whereas Sandra Washington was appointed to the City of Lincoln, Lancaster County Planning Commission on November 10th, 2016 to fill an unexpired term and has resigned to accept the vacant at-large city council seat previously held by Mayor Gaylor Baird. Ms. Washington has contributed over 2.5 years of volunteer service to the Lincoln and Lancaster County community as a member of the City of Lincoln Lancaster County Planning Commission. And whereas during her years of service, Ms. Washington contributed countless hours and diligent effort toward the adoption of periodic updates to the Lincoln Lancaster County Comprehensive Plan and Long-Range Transportation Plan, updates to the county and city zoning codes, and has reviewed over 500 development applications. Other projects and studies of major importance which came before the Planning Commission during her term include, but are not limited to, the 2018 Downtown Master Plan, Transit Development Plan, Commercial Design Standards, and New Parking Standards, Long-Range Transportation Plan Update, and Comprehensive Plan Updates, large-scale wind energy projects, streamlining the process of subdivisions and waivers of design standards, and review of various watershed master plans and redevelopment plans, South Haymarket Neighborhood Plan, Lincoln Bike Plan, annexation packages, accessory dwelling units, and capital improvement program conformity reviews. And whereas the growth and development of Lincoln and Lancaster County has benefited greatly from the years of dedicated service of Ms. Washington, And whereas in recognition of over 2 years of loyal and dedicated service, it is the desire of the City of Lincoln, Lancaster County Planning Commission to express their appreciation and gratitude and to commend Sandra Washington for her dedicated volunteer service and to cause such expression of appreciation and gratitude to forever be made a part of the official records of the Planning Commission of the City of Lincoln, Lancaster County. Now therefore be it resolved by the City of Lincoln, Lancaster County Planning Commission that the appreciation and gratitude of all are hereby extended to Sandra Washington in recognition of her dedicated service, support, and contributions to the public planning process for the City of Lincoln and Lancaster County, dated this 26th day of June, 2019.
Okay, so we'll entertain a motion.
So moved, Finnegan.
Second, Beckius.
Okay, discussion? Want to say anything to Sandra?
Well, thank you very much for your dedication and years of service, and thank you for continuing to serve our city on the city council, and it was a pleasure to work with you, and we will miss you.
Anyone else?
Yeah, I'd also like to thank you and say, ever since you came on the planning commission, it was clear that your background really qualified you for the position, and you've contributed during this time an amazing amount, and it's really shown the breadth of your planning experience. So I can't wait to see what you do on the council.
Others?
I've really enjoyed working with you, and I look forward to seeing you perform greatly for the city council and representing Lincoln, and so thank you. It's been fun. And your knowledge is incredible.
Well said by all the commissioners here, and thank you. Your leadership has been really fun to sit beside, and again, it's going to be fun to see how it goes as you're going forward. We're excited. Thank you.
You signed up for even more reading. Ha, ha, ha.
Thank you, too. I fortunately, well, unfortunately, Maya's leaving our community, which is, I think, a big loss. Fortunately, you're staying, and your role is even, I think, growing, and we really appreciate that. I know if folks know the relationship between Planning Commission and City Council, there's a relationship there that I'm really thrilled that you're on the City Council now and doing the work of that great group. So thank you very much for your service here. Okay, we need to vote.
Yes, we have a motion for approval for the resolution of appreciation for Sandra Washington. Beckius?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Joy?
Yes.
Core?
Yes.
Shear?
Yes.
Motion carried, 6-0.
So now Steve will present the plaque to you representing the Planning Department.
Again, on behalf of the planning staff, I'd like to present you with this plaque. And again, thank you for all your years of service. We know you would have had a much longer career with us, but we understand that you couldn't pass up the opportunity to further serve our community on the City Council. So I guess we can understand that as well. We also really appreciate that, very much like Maya, you had a lot of attention to our staff reports and the details, and we're often willing to dig into the details of that and to ask us tough questions, which we know you will keep in your role in the City Council. So look forward to that as well. And again, definitely your 25 years with the National Park Service, I think, both helped enroll in the Planning Commission and will help in the City Council as well. So, and I also really wanted to express our appreciation that when often nationwide there's often kind of a harsh partisanship, we really appreciated that you were open to listening to all sides, and that really greatly served you in the role of the Planning Commission. So again, thank you very much for your service. We know you have a great time on the City Council as well.
Thank you. Well, I really did think my tenure with the Lincoln Planning Commission, Lincoln Lancaster Planning Commission would be much longer. I'd sort of hoped that I would have been able to hear at the end of my service that I had worked on 5,000 development proposals. But I am really, really thankful for the opportunity to serve the Planning Commission and to learn so much about Lancaster County and the city of Lincoln in 2.5 years of getting to dig into issues that are really, really fascinating. And I've expressed to many of you personally that I'm actually a little jealous of the fact that you get to continue to work on a couple of issues that won't cross my plate in the city of Lincoln. I will probably still ask questions because I think those issues are so important for all of us, whether or not we live in the county or in the city. But thank you so much for letting me bend your ear when I had lots of questions, for being really good leaders when I needed someone to hold my hand and help me through the process. Thank you very much. And I look forward to working with all of you in my new role. And I hope you know that I have an open door, and though you may have to claim ex parte, I won't have to.
Thank you.
Thank you.
Okay, I would like to announce that there is a cake reception that will be held in Conference Room 303 of this building immediately following this hearing. Everyone is invited. Thank you.
Okay, we will now proceed with today's agenda. Please note that the Planning Commission action today is final on item 4.1, which is Special Permit 19025. Any aggrieved person may appeal final action of the Planning Commission to the City Council or the County Board by filing a notice of appeal with the clerk within 14 days following the action of the Planning Commission. The Planning Commission action on all other items is a recommendation to the City Council or the County Board. The next item of business is the consent agenda. Items on the consent agenda will be called at the same time and will not be scheduled for a separate public hearing unless there is a request from someone wishing to speak or at the request of a commission member. I'll ask Jerry to read all of the consent agenda items into the record. Once those items are read, she will ask if there is anyone wishing to speak. If you wish to speak on an item on the consent agenda, we will ask that you stand and state that item. That item will then be removed from the consent agenda and scheduled as a separate public hearing under today's Section 3 on the agenda. All items remaining on the consent agenda will be voted upon in total with a motion for approval. Jerry, will you please call the items on the consent agenda?
Thank you. I would note that Commissioner Joy has declared a conflict of interest on Agenda Item 1.1, Text Amendment 19003, and therefore will recuse herself from voting on the consent agenda today. Item 1.1 is Text Amendment 19003, amending Lincoln Municipal Code Chapter 27.02, definitions by amending Section 27.02.190 to add a new definition of retail sales, large items, and amending the section related to parking requirements, special conditions to add that small item retail sales require one parking space per 600 square feet of floor area, and amending a figure 27.67.040 uses with special parking requirements to add retail sales, large items, and repealing said sections of the Lincoln Municipal Code as hitherto existing. Item 1.2 is change of zone 19017 from R6 Residential District to B3 Commercial District on property generally located at 534 North 27th Street. Are there any ex parte communications to be disclosed on these items?
I see none.
Is there anyone here wishing to speak on either of these consent agenda items? If so, please stand and state that item.
Okay, we'll entertain a motion.
Move approval, Core.
Second, Beckius.
Okay, let's call the roll.
Okay, this is for approval of the consent agenda. Beckius?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Core?
Yes.
Shear?
Yes.
Motion carried, 5-0.
I will now ask Jerry to call the request for deferral.
Okay, I would just announce that under item 2.1, request for deferral, we received a written request on behalf of the applicant to place this item, which is preliminary plat 18002, on hold until further notice.
I'll move that we place the application on hold.
Second, Core.
Okay?
Okay, Beckius?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Joy?
Yes.
Core?
Yes.
Share.
Yes.
Motion carried, 6-0.
Is there anyone present wishing to testify on preliminary plat 18002 at this time? Okay, we will now proceed to public hearings. The staff will make a brief presentation. The applicant will then be requested to present his or her testimony, followed by those who wish to testify in support, followed by those who wish to testify in opposition. The staff will then be given an opportunity to respond to the testimony, and then the applicant shall have an opportunity for rebuttal. If during your testimony you have copies of documents or materials you would like distributed to the Planning Commission members and/or included as part of the record, please provide that information to the clerk for distribution. Each person testifying should state their name and address and shall have 5 minutes to speak unless additional time is requested and granted. The timer will go off after 4 minutes, then you will have 1 minute to wrap up your testimony. The Planning Commission will vote immediately at the close of the public hearing unless the commission votes to defer action or continue the public hearing. Jerry, please call the first public hearing item.
Okay, item 4.1 is special permit 19025 for a community unit plan for one residential lot with waivers to drainage study, grading plan, sidewalks, and post-construction storm water management plan on property generally located at 66th and Pine Lake Road. This is final action on this item unless appealed to the city clerk within 14 days. And staff recommendation on this is denial. I would also indicate that on behalf of the applicant, there was an appeal of denial of request for deviation provided, as well as a motion to amend, and that those items have been distributed to the Planning Commission members. Are there any ex parte communications to be disclosed on this agenda item?
Yes, I had a conversation with Ann Post.
Others?
Thank you.
I also had the applicant's attorney call me to ask if I had any questions about the application, and I had not read the application yet, so I didn't, but I wanted to disclose that.
Okay.
Dean, I think you have to state what your conversation was about.
Ann called this morning and just kind of went over the motion to amend, and that was it.
Okay, Brian?
Okay, good afternoon, Brian Will, Planning Department. So the property that we're talking about today is this one, dashed lines here. We're at 60 South 66th Street and Pine Lake Road. And maybe just clarify before we get too much further, because it is kind of can be a point of confusion. We're talking about, when I say lot, I'm usually going to be referring to the larger. This is lot one, all of this. A condominium regime was formed several years ago, and interest in the western portion was sold off. And so what we're talking about today is this western, about 1.5 acres of lot one. So this special permit for the community unit plan would only be over this portion of the lot as proposed before you today. Why a CUP? What does it do here? The goal, I think today, as has been for, well, dating back to 2003, is really to get access to Pine Lake Road for this proposed lot here. So the proposal today within the community unit plan essentially shows this area within the boundary of the CUP, but proposes to create a private roadway. And so, as you all know, that the only way to create a private roadway is with some sort of zoning overlay, PUD, planned unit development, use permit, or in this case, a residential community unit plan, CUP. So the CUP is proposing only one lot, private roadway stub here, for only one dwelling unit. So as I mentioned, this question has come up before. There is a history to this property, and it dates back, sort of start at the beginning here, dates back to 1982, and I don't expect anybody to really be able to read the fine print or the detail here. I just want to point out a couple important facts. This is a larger preliminary plat for the area, including the lot or the property we're talking about today. And there was a note on this preliminary plat, states back, it's approved in 1982, that these two lots, this one here, subject property today, and the one across the street, both relinquished access to Pine Lake Road. So, meaning they had to take access to the internal street, which the way it was laid out and the way the lots were laid out and the street network, that was not an issue. So one of the final plats then, the first final plat that involved this property that we're talking about today was Country Place Edition. And I just show this to show you how, to talk about the history of this property. So this lot here highlighted in blue, this was the original Lot 1. Now what I would mention though, is that within the dedication of this final plat, there was not a mention of relinquishment of access to Pine Lake Road. Now, I don't know if that was because it was deemed not necessary because it had already been done with the preliminary plat, I'm not sure. But in any event, subsequent to that plat, however.
And Brian, that was the final plat you just
That was
showed
a
us?
final plat,
Okay.
yes. Then the final plat that gives us the lot that we're talking about today, and I dashed a line in so we can see essentially the two parts we're talking about. But that was Country Place 7th edition, and it was clearly stated on this final plat that access to Pine Lake Road was relinquished with this lot here. So it was in October of 2002 that an administrative final plat been submitted to the planning department, essentially to create the lot that we're talking about today. It was noted during that review that actually the city council had approved the original preliminary plat, so that condition would need to be modified by the city council. So that administrative plat didn't go anywhere. A final plat that would go back or could go back to city council was submitted. And again, it was essentially looking like this final plat of 7th edition that created the entire lot, but that it had a line here. And so it delineated lots 1 and 2. Subdivided lot 1, created 2 lots. That final plat went through both Planning Commission and City Council. It was approved by the Planning Commission upon the condition essentially that the applicant work with the city at such time as Pine Lake Road was improved. Excuse me. That condition was then modified by the City Council. While they did approve the final plat, they modified that condition to say that essentially this owner, this lot, would actually need to take shared access with the property to the east of it, which is the church that I'm sure we'll talk about at some point before we're finished here today. So that was the condition under which that final plat was approved. And by the way, I would note that there was a change of zone that was submitted as part of this package to accompany this, this final plat. The original recommendation on this change of zone to change all of this, actually this larger area here to R1, was deferral until the issue with access on the final plat were sorted out. Well, I think at the request of the applicant, and I think the Planning Commission agreed with it, was to go ahead and move that forward. It didn't really encumber the city or add any requirements relative to access other than to say it's changed to R1, subject to a final plat, though, that comes forward and gets access along with the church to the east. So that's sort of a synopsis of the history that brings us up to today. The request for the special permit for the CUP, as I said, creates the one lot, but does need access or counts on access to Pine Lake Road. Well, it required a deviation request also in order to get that. In your packet, I included that deviation request and the letter of denial from Lincoln Transportation Utilities and Building and Safety. So that request was denied. I believe that that is going to be or has been appealed to the City Council. And depending the outcome of today, this may well be appealed as well. So it's it's the history of it and the consistent message from the city that another driveway, an access point, not be allowed onto Pine Lake Road is what we're saying again today. We're recommending denial because of that fact. And that's been the consistent message since we first started talking about this area in 2002. I'm also suggesting that the scenario here, a lot adjacent to a major arterial street with access also to a local street, isn't any different than many other lots throughout the city that could make the same claim that they would like to have access to their property to the arterial street in order to facilitate additional subdivision. Well, that has not been the case from the city's standpoint to allow additional driveways. To the contrary, the access management policy, excuse me, the time of redevelopment requires driveways be eliminated when possible. So that's the primary reason for denial of the deviation request is it's completely inconsistent with the access management policy as it exists. So I think with that, I'd be more than happy to answer any questions you've got. By the way, so started to get into it, the recommendation for denial on the waivers and the application itself is because of that. Now, we did add conditions if the Planning Commission chose to do contrary and approve it, to set it up for being approved as part of a CUP, okay? So we did include those in case the Planning Commission went that direction. So what I guess we've argued is that this circumstance today is entirely of this owner's making. The condominium regime was formed after the conditions were imposed by the City Council, so with full knowledge of those conditions. And really circumstances at this location have not changed at all since 2003. For that reason, we're recommending denial. So I'd be happy now to answer any questions you might.
Brian, how do they access that property now?
Okay, as I said, now this is all one lot here. It's accessed, there's a driveway right here, kind of to the northern edge of South 66th Street,
Okay.
like right about here. I think that driveway just extends sort of straight back here to the garage.
But currently, the condominium has no direct access to public right-of-way.
Correct. Yes, it has been relinquished, actually,
Yes.
on at least 2 occasions, right?
And the church, is it an active church or is it?
Yeah, right, it is. Yes, it's an active church, and they have at times been involved in this discussion. I don't know the extent of the applicant's discussion. I'm sure they can answer that question for you. But at least on one occasion, they were here and met with staff and others, maybe a year ago, something like that.
Can you walk me through the kind of timeline and practical way of solving this if the denial of request for deviation goes before the city council and they were to accept their request? How does this all tie together? Because I'm assuming that we can't waive in an access management policy in this case.
Right, that would go to the city council, correct. Yeah, I think the intent would be to have.
Look like, what would, if we were to grant this request, say, would that just go to the city council and be followed by this appeal, or does that need to be a condition?
Be for them to go together,
Okay.
and perhaps to do that, I don't know, in hindsight, maybe adding a condition to the CUP that, something to the effect of having an approved deviation request. I don't know that it's necessary, but I'm listening to you talk and I'm thinking that, that probably would not be.
I guess
probably
that's
not
what
would be
it's
harmful.
probably the essence of my question is,
But I don't.
is it all moot if the city council doesn't
But this is final action, so would it even go to city council?
It could be appealed.
But
If-
the denial of the deviation request would still go, right?
Yes, that's
And then
that's
the
been appealed to
conditions-
city
Then the
council.
conditions would have to state that they, of the CUP, that the council approves the request, or?
Yes,
Okay.
yes. So I think, yeah, so as I said, I think the intent would be, so if this were, excuse me, if this is approved, although the applicant has a motion to amend, if this were approved, then that deviation request still needs to be, is appealed, that still needs to go to council and be acted upon.
Okay.
Okay? If this were denied, my assumption would be the applicant would also deny, appeal this decision to city council with the intent of having both of those items there at the same time.
So follow-up question to that, if we did not accept, well, let's say we accept your recommendation to deny,
Okay?
but they go forward with their deviation request appeal to the city council, if the city council accepts and waives the access management policy, or however that works, would your recommendation be the same? Would it still be denial?
We're not gonna be
If this came back?
Well,
after
we're not going to
that-
be involved in it at that point at the staff level. I mean, that's a sort of a hypothetical. If the council approves that, then does your opinion on this change?
Okay.
At this point, we're talking about review and recommendation at staff level, and
Right,
there's been that denial from the directors of building safety and LTNU. Based upon what we have and what we know today, that's the formulation of our
the only
recommendation.
reason I
here.
ask is if there's a reason to defer this and have them go forward with their appeal and then
no,
see
I-
what, but no.
I think we're suggesting no, that ideally they would go together.
Other questions for Brian at this
I'm
time?
gonna piggyback on that just a little bit. So if, say that city council does reverse the decision on the access point, does the applicant then have to come back through planning commission?
I think whatever, if any changes, because they're going to appeal the special permit as well. So if there were any changes that need to be made to these recommendations for the council, then, because it's presumed then if they're going to approve that they would approve the special permit. If there were any modifications to those conditions, they'd be made at that time.
Thank you.
Brian, is there any coming together between planning and the applicant? Is there anything that can be done? This has been going on so long. Times change, situations change. Is there any compromise that you see that you've offered in this process?
Well, the two most likely options, that is access back to 66 or sharing with the church. Yeah, I mean, there's not that many. There are not that many options, to be honest with you. I don't know that I can think of a third one. But that, I mean, that was the dilemma with this one from the beginning. That we noted from the very start. It's like the change of zone is good. We anticipate this area moving forward to look more like R1 than AGR over time as property subdivided. But that redevelopment needs to happen in a way that's consistent with policy and standards. And that by approving this other driveway, that's not what we meant. We meant do it in a way that's consistent and doesn't require these kinds of waivers and exceptions, especially on our arterial streets.
Brian, regarding the access management policy in this stretch of road on Pine Lake, I know that there has been some development along this stretch.
Mhm.
Do you have at your fingertips the knowledge of how both to the east and to the south, some of those existing properties have dealt with the access management policy right here, and how they've resolved that?
Yep, maybe let's.
I think that would be helpful.
Let's use this one. So here's the church. Here's the mini storage and office development at the corner. And so they were allowed, because they had an access point, so they were allowed an access point with that development. Can't take away their only access. But as part of that development, they were required to provide a connection to the church here. Here again, that's sort of the typical, in anticipation of eliminating those driveways on Arterial Street, that would leave the door open for potentially eliminating this driveway, okay? If we go to the south, recall dating back to the mid-2000s, there was a PUD that was approved at the southwest corner of the intersection, residential, a bit of office, a little light commercial. And so as these other properties down here have, with the improvement of Pine Lake Road and the fire station, which is now located here, as this development has continued to occur, we've employed the same strategy there. What we've done, the PUD at the corner, we've expanded it now to include all of these properties. And as they come in and they want to change their use, change anything, they will relinquish their driveway and take shared access where possible. And that's exactly what happened to the company right next door to the fire station. They now will share driveway access with the fire station to Pine Lake Road. Right next to the PUD at the corner, there's and I think he has a sign up, it's limited automotive repair. The guy is working out of a garage that he had. Well, as part of his change, he also has to now take access to the PUD driveway. So when it develops and they install their access point, he then relinquishes driveway and will take access to it. So at the time that the party that is causing that zoning action does something, that's at the point where we say your driveway, if possible, has to be eliminated, and you need to take access with the property adjacent to you, okay? So the difference here is that with this property we're talking about today, the church isn't doing anything. The church is just sitting there. So short of condemnation, to go in and condemn that driveway and move it or somehow give this owner access, and we typically that is not the way it works, right? If you are the party causing the action, causing the zoning action or redevelopment, then you're asking for something from the local government, and that's when you can lose your driveway and take access to the property to these. So yes, especially to the south, as these properties are redeveloping, coming in. Matter of fact, the house, I think it's this one right here. We brought that one into the PUD. Didn't change anything there, but at such times he wants to come in and change the use from anything other than a single-family dwelling. That's at the point where we will look to be eliminating that driveway and some opportunity for shared access as well. So that's the typical, you guys have been around, you've seen how that works. That's the typical strategy for dealing with these issues. But in the case of this one, the church is not doing anything. Church has initiated nothing.
Okay, thank you.
Did I understand that correctly that the church actually said they didn't want to share their access?
That's what the applicant has stated, yes.
If the owner were to get the church to agree to sharing a new access, could you close the church access now?
If they came forward and willingly agreed to something like that, yes, I think that's entirely different. Now I probably would need Public Works maybe to sound off a little bit on this or chime in, because I made the other point about the location of these access points, and really the location of the church driveway is closer to the ideal location for an eighth mile access point. The further you move to the west, the less ideal that becomes. So here again, it's another reason for this one being the better location for the 8th mile access, as opposed to moving it west, where that distance increases is less consistent with the management policy.
When in 2001, 2, and 3, when you were talking about having that access be one single road, correct? And so there's nothing tied from those CUPs so that it had access then?
No, neither one of these are under any kind of zoning overlay at this point. That final plat was approved, subdividing this lot into two, with the condition that they get some cooperation from the church and share that access point.
Was the church built at that time?
Oh, yes, yeah, the church was there.
And at that time, no agreement had been made?
That was the condition, that they then go out and seek an agreement with the church, and I don't believe one has been reached.
And so, as a city, how do we deal with that fact? Because, I mean, obviously, we're trying to do what's right for the arterial street. So how do you do that with other properties in the past where you have someone that isn't affected, like you said, but doesn't want to do it, and doesn't want to change what they have? So then what do you do?
You wait. In a lot of cases, for an example, what you guys just remember seeing these developments. This is Firethorn Lane coming into Firethorn, South 84th. As these large lots here have redeveloped, well, we were talking to several of these property owners over time, and there were one or two that were ready to go, but the problem was they knew, well, they didn't know. What we told them was, we're not going to be supporting any more access points on 84th. We're going to figure out some way to build this internal street network, which, as you recall, the use permit here by Phil Wenta. So that started the street network here to the north. Skipping a lot coming south, then that stub street has been extended in. And so now we're building the street network internally to serve these properties as they redevelop. I mean, so I don't know what the future is. Every time I say it'll never happen, it happens the next day. But there's more than one way for areas to redevelop, and potentially there's going to be one here as well.
Is there room on the city right away to put a road in for them that connects so that everyone wins?
You mean to go?
Yeah, because you've talked about that completely tying across to the corner development, correct?
Well, this development here was required to put a street to this line here, or an access easement to this line here.
But it doesn't go anywhere, is what you're saying?
Doesn't go any further than that, because here again, the church, they haven't done anything. Church has not done anything. So, yeah, so there's really nothing new. There's no new twist on this. This was 2002, 2003. This was the circumstance we understood then. And so,
I was just wondering if there's a way for the city policy or whatever the right terminology is to help alleviate that if there's property owners that have their own thing going. Like you said, now how do you connect that two together to get? Interesting.
yeah,
It's a big
like I
problem.
said, it's always an issue of timing, unfortunately. And yeah, at
But
this
it could
point,
be 70 years. I mean, it could be forever.
it could be. Which, as I noted though, that was a concern thrown out originally. We should not be subdividing this property unless we can do it consistent with, that was our message from the very beginning, we wrote it in a couple of staff reports, two of the staff reports for the changes on the final plat. Yes, exactly. And especially Pine Lake Road the concrete's just now drying on this portion of, I don't know how many, Public Works estimated some value to that, but on the new arterial street it's just been completed.
And it's a big
And
street.
so there's no desire on Public Works part to go in now and be modifying with, turn lanes and additional driveway access points.
Brian, if the road was to go in, where would it be?
The community unit plan shows that road coming in over here, right next to the very eastern
Yeah.
property line. So then, because what they're proposing is then at such time as the church redevelops, then they take access back to this point. Okay, so it's close enough or it's on the property line. I mean, again, our issue with that is that, I mean, perhaps there's some value to this owner of having that access point on their property, as opposed to what we're doing in effect is just moving it to this owner's property.
Sounds like the church is holding a lot of the cards here.
They are, that is, yep, it's true.
Brian, can you show me, they talk about the the eighth quarter access and the quarter access. Can you show me like where the eighth?
I think in my math, in my staff report,
I'm just
okay.
wondering how well it would match up to that entrance on the south side.
This one here?
Well, I was looking more towards
Or
the
this-
east.
This one?
Yeah.
I think we're talking about maybe 100-foot differential. So beside, like I said, this one.
So that's not quite an eighth of a mile either, but.
No, admittedly, it's not. And that one was problematic because of access as well. But this driveway to this house goes away when that commercial redevelopment comes in. So it's probably, I don't know, it doesn't write, somewhere at about that location. Putting the church at an eighth mile exactly the eighth mile would probably be somewhere at that location, it looks like. So they're still perhaps a little bit offset.
And this being a minor arterial, we're really wanting it at a quarter mile, not eighth, correct?
Well, it does allow for or an eighth mile access point. Okay.
But if we were starting from scratch, the preferred would be at a quarter?
Well, yeah, I think what we're saying, that South 66 is at a quarter, okay? It does allow under
Sure,
circumstances for the eighth mile
sure,
at the 660 feet. We're a little bit off there, but
sure. I don't know if other commissioners are done with questions. I have some road-related questions that may involve Bob. And Brian, it may involve you too, so.
Just keep in here.
I'll be close.
So, generally speaking, let's say this has been going on since 2003, the idea that the owner has done something and relinquished their control and access without any guarantee of any access moving forward. Could you discuss, Bob, a little bit about the process of the arterial improvement on Pine Lake Road and the discussions that LTU had with neighbors in terms of access points throughout that process? As you look up and down the arterial improvement of Pine Lake, you'll see such things as the combination of driveways. You'll see some new stubs in there too, and then the addition of a new collector on the west side there, hitting Pine Lake. Can you discuss specifically in terms of this parcel, condominium unit, how, if the city had any interaction with the owner throughout this planning process?
I wasn't involved in the right-of-way acquisition on any of this, but just in general, I can talk about those items.
Sure.
Obviously, the goal on the arterials and minor arterials is to limit the access to the quarter and eighth mile. The eighth mile being right in, right out, with a median section in there. In this case, on Pine Lake Road, when the negotiations were going on, all of those access points were considered as, could they be eliminated, could they be combined? And it's not a perfect process because we can't force everybody to do everything we want them to do. So there were some situations where they relinquished access based on the neighbor doing something and moving ahead at the time that those actions took place. In this case, there was a specific request about this parcel. Were we required to provide access to it? And the response we got from the law department was that we were not required to provide access to it. The conditions were there prior to any improvements on Pine Lake Road, that access was relinquished, and it was conditioned, that development was conditioned on combining that access with the church. Since the church didn't agree, then there was no step that we could take to force that to happen.
Sure. Do you know, Bob, throughout the planning process of the arterial improvement on Pine Lake, the city is going to be providing a new stub to the church for connection to Pine Lake. Do you know if a discussion was had at that point in time by the city of Lincoln to change the location of the stub provided to the church?
There is not a stub of right-of-way in there. There is the maintenance of their driveway. So there was not a turn lane built there, and there was not an additional right-of-way acquisition taken for a future road.
Right.
Ideally,
I think that, correct me if I'm wrong here, Bob, the improvement of Pine Lake was going to damage a portion of their driveway.
oh, certainly it would.
Right.
It would.
And so I think the city is going to be paying for the installation of a new portion of drive.
Oh, certainly.
Yeah.
If we
And
take
so I
out,
didn't know if there was a discussion at that point in time, knowing that the city was going to be destructing and then reinvesting in that drive, if any discussion had taken place about the relocation of said drive.
that I can't tell you.
Okay. I lost it.
Were you going back to the word relinquish?
No, I apologize. Go ahead, commissioners, if you have
Well,
any
I'm gonna
questions.
springboard. What you're bringing up, Tom, is exactly what I was wondering. So when those properties relinquished, when you have a property relinquished, does that require something else to happen? So do they relinquish because they think they're getting that access?
Prior to that development, they probably had access to Pine Lake Road by right because that property was there. When they subdivided Country Meadows, or whatever the name of that subdivision is, because we didn't want them to take access to Pine Lake Road, we required that they design it such that all of those lots could take their access off of streets within the subdivision, and therefore protect the arterial road from a number of access points.
A couple other questions. So if a private drive were installed, Bob, that connected directly to Pine Lake, I'm assuming that would the city have exceptional requirements that they would like to see in terms of a longer throat or a wider throat or anything like that to the connection to Pine Lake?
The condition on getting a connection to Pine Lake that would be standard would be that you would build it to typical street standards, which would be a 27-foot wide street, but it would also, on the arterial, have a turn lane provided, a right-hand turn lane.
Sure.
And those would all be the obligation of the developer, and those are the conditions that they ask to be waived.
Okay. Question about the turn lane then too. Looking at the access management wording in there, if we're hitting under 100 cars a day utilizing that access point, then the city's not requiring a traffic study or anything of the sort. But a turn lane is still a requirement,
Yes.
even if a traffic study is not necessary because the amount of volume is so low?
That is correct.
Okay. And then could you discuss a little bit as the city, or as annexation occurred on the south side of Pine Lake here, and the city decided to build a fire station at that location too. Could you discuss a little bit of the city's process that LTU maybe went through or planning department, maybe this is a question for Brian, went through with those property owners to work with them to talk about how that process would go and how the consolidation of driveways would need to occur?
Brian might be able to help me on the specifics on those. But certainly when we're doing these right-of-way acquisitions and these designs, our goal is to reach the standards of our access management policy.
Sure.
And we recognize it may take, time as properties develop, to put conditions on them that
Right.
could be met at some point.
Yeah, and sort of follow up on that. So at the time that these property owners on the south end, there's two of them that we're talking about at this point. At the time they came in and asked about, changing the use on the property, which is single family, to, in the case of the guy that now does car repair, and the other one next to the fire station, which has a drywall company, I believe. At the initial meeting, one of the first things that you talk about is access to the arterial street and how that condition is going to change if they go through the process of having that amendment to the PUD approved, that then their driveway essentially goes away and they'll be sharing access with somebody else. So it's one of the first things that you talk about when you're developing or redeveloping property, or developing farmland for that matter, along an arterial street.
Thank you.
Anything else?
This might be for Bob. When we're doing, widening something like Pine Lake Road, and they have to do that right-of-way acquisition, when do they when would this property owner have been notified? I'm assuming that you had to acquire some of that right-of-way from this property owner,
I would say probably well in advance of a year before the project.
at least a year.
And there's any number of neighborhood meetings about the projects, things of that nature.
Thank you.
And Bob, do you know when the property owner would have contacted your department in that process, if they did?
I don't know when they did or if they did.
Okay, thank you.
Anything else for staff?
So it would have been
Presentation.
appropriate at that time to maybe start some of these conversations if they wanted to change, like to,
Steve Henriksen, Planning Department, I can add, they did. They came in and contacted our department, they contacted LTU. I don't know if Bob was in those discussions, but the attorney representing the property owner did come in and ask, hey, we'd like to get access. We have this old resolution that says you can subdivide your property if you can get access to the church lot. Can you help us do that? Just so it's clear, there's not a lot here. This is a condominium unit off the back lot. The lot is the bigger lot. So there was no obligation of LTU, as Bob stated, to provide this condominium unit with access. And so we didn't view it as the purpose of the city to force the church to provide access. If the church wanted to share the access, they could. And it sounds like, as we understood from the applicant, they had those discussions and they were unsuccessful in getting the church to do it. Because you have to remember, the Hannons owned this entire lot. They had the chance to create a panhandle lot, 266th Street, create both lots, and this would have all been over in 2003. And that is a common thing that we see. We see that in a lot of other circumstances where if you can meet the subdivision ordinance requirements and the zoning ordinance requirements for lot depth and lot width and lot area, we have other panhandle lots that have been created. So they had the opportunity to create a panhandle lot with an access back to 66th Street. Maybe it would have been a shared driveway for those two. Very common for it to be a shared driveway. And they would have had access to 66. They would have created two lots. So we weren't opposed to the creation of the two lots, but we were opposed if one of those lots was going to have access to the arterial street. And that's also the difference between this and all of the discussions with the other properties. The other properties already had a driveway and a legal access to Pine Lake Road, and that was their only access to Pine Lake Road. There is no obligation to provide this property with access. They passed on creating their own access to 66th Street and sold off the front part of it. They gave up that chance. They took their chances with working something out with the church. That didn't work out. So they're going to their third option, which is to request the city council to say, well, give us an access point here, even though it's contrary to your policies. And we're recommending against it. And we also think it's a bad precedent because we have other acreage lots, other large lots in the city that back up to arterial streets. So there are other properties that could be in this similar circumstance. I have an access off a local street. I want to subdivide off the back. I don't want to share access with them. I'll just go ask them to take access off of 70th or 84th or any other street. And so that's part of the reason here is why we have recommended denial.
Thanks, Steve.
Thank you.
Anything else? for
That answered my
staff?
question. Thank you.
Good, okay. We'll take testimony from the applicant.
Good afternoon. My name is Ann Post. I'm an attorney with Baylor Ebden Law Firm, and I'm here today on behalf of the applicants, Vic and Kathleen Hannon. So, as you're aware, our ultimate goal with this CUP is to gain access to Pine Lake Road. The Hannons have owned this property for over 16 years. They want to, all of their children and their family is in Lincoln. They want to build their retirement home here, to live next to their grandchildren, have a nice retirement here. So you've heard a little bit about the history of this proposal. In 2003, a subdivision was brought in front of the Planning Commission. Ultimately, the Planning Commission approved the two driveways and said, but they'll be combined when Pine Lake Road widens. Then it went in front of the City Council, and the City Council said, go back and try and work with the church. And there was some understanding that it would be addressed when Pine Lake Road widens. In the meantime, we have made every effort to work with the church to gain access. I can tell you that we have offered the church $10,000 for that access easement. We heard a rumor that maybe liability was the issue. We offered indemnifications or insurance or whatever guarantees they needed. Basically said, here's our starting offer, but tell us what your concerns are. We'll work with you. They hold the cards, as Commissioner Finnegan said. So we operated from that standpoint. I can tell you every time we had the opportunity to talk with someone local from the church, they were very cordial, they understood what we were saying, but they told us all decisions are made in New York. Once we sent them offers in writing, they said we forwarded it to New York, they're going to handle it from here, and we haven't heard anything since. So we've made every effort we possibly can to work with the church, from open checkbook to indemnification, and we've been unable to make any headway on that front. When the process of widening Pine Lake started, yes, we reached out to the city. We tried to get everyone around the table and say, what can we do to gain access to this parcel? As you can tell, negotiation, we've been talking about it for a very long time, and as Steve said, now we're on option 3, which I can tell you that as far as setting a precedent, this is not a precedent I would want any of my clients to follow. It is not an easy way to gain access. It's not a cheap way to gain access. It's definitely option 3. So what are we proposing to get to that? What we're proposing is that we're asking for the private roadway, we will build the private roadway, and we will give the church to the east access to their property from ours. Now, Brian went through the history of how this has been done to consolidate access up and down Pine Lake as Pine Lake Road was widened. And the difference there is that it was every time that the property owner asked for a change of zone, they said, okay, but you're going to give access to your neighbor. Here, we don't want to wait for our neighbor to ask for that because, as we've said, it could be years. So we're saying we're going to take the burden of that change of zone on ourselves. We're going to reverse that role. We're going to take the burden. We're going to offer to build the road. We'll give you the easement. So we're taking that burden to have that access and consolidate access. So ultimately, what we're proposing, we will build the private roadway on our property. We will provide an access easement to the church. So at such time as they redevelop, that at that time it can be required that they take access via the private roadway that we have paved and we have provided to them. So yes, there would be a period of time where there'd be 2 accesses, but when that property redevelops, it can be required that they take access and from our property and 1 access point be eliminated. Again, as Brian said, this is not unique. It is a slightly unique twist to a method of consolidating access that has been done up and down Pine Lake. It was done with the Franklin Drywall, and it was done with the property just to the southwest of Highway 2 in Pine Lake. As Brian mentioned, we have offered a motion to amend. You've been circulated a copy. I have a slightly changed copy here that I'm going to hand out. The only change on this one is that we retained item 1 under site-specific conditions, that we will give you 3 copies if you approve it. So I have given that to the law department. I don't think they have any objections to less red on the page. So this motion to amend is because there are a few unique aspects to this. First has been addressed, this is a condominium unit. It's not a legal lot, separate legal lot, but under state law, zoning and land use regulations can't impose restrictions on a condominium unit that are greater than you would require on a legal lot. So it has been suggested that if you approve this, you do it and require a subdivision of the lot, a subdivision of the condominium unit, so it's 2 separate lots. So may I have time to continue?
On, yes.
So it's been, a condition of approval has been that we subdivide. Our response to that is that subdividing adds nothing to this. It adds nothing to the substance of what we're trying to do. The CUP, this CUP application, the sole goal of this is to dedicate that private roadway, and we can do that without a subdivision. What it does do is complicate and, again, inhibit our ability to move forward with this. Because as part of that subdivision, we would have to bring in the Burbacks, the property owners to the west, and we would also have to get their lender to sign off on that. I can tell you that I have spoken to Ms. Burback, and she told me that in her opinion, that would be nearly impossible. So this is why we would ask that the conditions that require a subdivision be removed, and we'd be able to proceed on this in its current state as a condominium unit. The next thing I'd like to address is our request for deviation. This has caused some confusion kind of with the timing of everything. I can tell you that I have talked to Brian Will about this, that we kind of went back and forth with exactly how to time and everything. Our issue is that the CUP gives us the private roadway. The request for deviation gives our right to have that private roadway connect to Pine Lake. One is not a whole lot of use without the other. Because we didn't feel it would be appropriate or that we would achieve much success requesting that with our request for deviation without the conditions that we provide access to the church lot, that we pave the road, that we take those obligations on ourselves. We also knew that our CUP wouldn't gain much traction if we didn't have the access point for that roadway to actually access Pine Lake, which is why we have this unique situation where we're bringing them forward together. So with our motion to amend, we're asking you to include a condition that, assuming that you approve this on the condition that we receive approval of that request for deviation. That way, we would still need to receive that approval for the CUP to really have any practical effect. Now, as far as our request for deviation, we requested that for all of the reasons we have stated to gain access to Pine Lake Road. It was denied for 3 reasons. Let's see, the first being that there's the question of LTU's authority to actually grant access to Pine Lake Road. As has been discussed, the access was relinquished via final plat approved by the City Council. So the question is whether anyone but the City Council had authority to grant access. Once we have with this appeal to the City Council, that resolves that question. The next issue was the uncertain timing of when access would be consolidated. To that point, yes, it is uncertain when access is going to be consolidated between the church and the Hannon's property. With the point also being, though, that we're looking at a single-family use. We are both required to have single-family use in the condominium regime that established the lot, and we're providing the requirement in the CUP that we limit it to single-family use. So we're looking at a small number of trips every day, and the church property is currently zoned R1. At the time when they redevelop to something commercial that's going to generate more traffic during peak hours, that's when they can also be required to take access via the access that we've provided. And so while it is uncertain when access will be consolidated, it's going to be consolidated. It would be consolidated at the time that we actually start to generate more trips. And finally was the issue with the right turn lane. Again, we're looking at single family use. We're looking at right in, right out. This is going to generate very little traffic during non-peak hours. Church would have some traffic, but again at non-peak hours. It's been pointed out that the church could add a school or a daycare and that would also generate trips and during peak hours. Our reply to that is that the church can do that now. If they're allowed to do that under R1 zoning, they can do that now with their current access to Pine Lake that doesn't have a right turn lane. So while that would cause, if they were to do that, it would cause congestion, this access point isn't going to exacerbate that issue. So with that, it's for these reasons that we're going to ask you to approve. We ask you to approve the CUP with the amendments to conditions that we have proposed. With that, I'd be happy to take any questions from you.
Have you shared your specific plans with the church? And have they opined on your plan?
I can tell you that I did call the church Monday. I was able to get a hold of their local person to talk to them about this. I explained what we were doing, let them know that this hearing was happening. That was Monday. I haven't heard back. I haven't had any questions. They haven't given me any feedback on it. So, one way or the other.
Have you contacted the New York office?
They sent us to the New York office. They didn't provide any contact information. I tried some Google searches, but they were not very fruitful. So,
The planning department is making the argument that because this situation is, in their words, of your own making, or of the applicant's own making, exceptions shouldn't necessarily apply. What's your response to that?
My response to that is first that this type of infill development is consistent with the comprehensive plan, in that we know that we're going to have to continue adding houses to Lincoln, and that the goal is to do that as infill development that utilizes our existing infrastructure for more housing in Lincoln. The second issue is to that it's going to establish a precedent that other people will use. I can tell you that this is a precedent I would not advise my clients to follow. That it's one that it's expensive. So I think there would be several other options before we got to this. I don't think that this precedent will exist in the future as it exists now. It's the third option that's not the preferred option to come forward this way.
Thank you.
Anything else? Tracy?
Do you know, how does the applicant access this portion now to do things like maintain their lot, like mowing? I mean, how do they have an agreement with the people to the west?
See, I can tell you that I know they do mow it. I do not know how they get a mower onto the property, but the applicant is behind me, and he's going to give you a few minutes of his history on this and ask you to approve this, and that'd be a great question for him.
I know that, so you mentioned that they've talked to, the property to the east, the property to the west, but what about, and I don't know why the property owner to the north would want to do this, but have they addressed this with the property owner to the north where there's Ann's Court up there, they could take access off of there? Have they even approached that person?
I believe they have, yes, and that the issue was that any access was going to go right past their kitchen window, that it would have a significant negative impact to their property, so they were not willing to consider it. Again, I haven't talked to them personally, and I know that my client would probably be able to add more color to that.
Thank you.
Anything else?
Yeah. So, Ann, Ms. Post, could you discuss, I'm mostly interested in the discussions that took place between the Planning Commission approving the subdivision and then the City Council approving the subdivision or condominium regime, and what took place specifically from the City Council's point of view at the time of approval in terms of their discussion of this issue ought to be sorted out when Pine Lake is improved. Could you tell me what you know?
Yeah, I can tell you that mostly what I know is from what you're going to gather from the documents that were included with the staff report.
Sure.
That the original resolution from the Planning Commission said that they were going to allow access, but that with the condition that they were going to be combined. At the time, Pine Lake Road was widened. And then that, I would have to look at the exact wording that is also in the packet, that the City Council changed that to say the applicant will seek an access easement with the church to be combined at the time Pine Lake Road was widened. So it wasn't real clear exactly how that was going to happen when the Pine Lake Road was widened, but that because Pine Lake Road widening would trigger issues of these access points, where access is, of trying to consolidate access, that was the idea being that was a trigger point for when this discussion would be picked up again.
Sure. Do you think that the city council anticipated that in owner they had no control of would be willing to negotiate with this landowner?
I think that usually when you pick a large amount, well, you offer a large amount of money for an easement and pretty much allow them to write their own easement, City Council would have anticipated that someone would be more willing to accept that. And I think that also City Council probably didn't anticipate it would take 16 years to get to the widening of Pine Lake Road. So I think that City Council wanted to make sure that the option to work with the church was fully explored before any sort of special access or different access was granted. And I can tell you we have done everything we can to explore that.
Okay. Could you explain to me a little bit why your client would create this condominium regime without any form of access, knowing the entire time that they had relinquished access to Pine Lake Road?
My understanding of that was that the property was under contract to sell at the time that the process was going forward, and that they needed to close on that contract. And so this was a way that they could close on the contract to sell that property and I also understand that they worked at selling the larger lot, but they had difficulty selling the larger lot just because of the price that much land in that area of Lincoln would command. And so that's why there was entered into this contract that sold a smaller portion of that with the idea of subdividing it. And that when faced with the situation of being under contract and needing to close on that contract for only that amount of property, they found a way to do that.
Okay, thank you.
Anything else? Thank you. We'll go to testimony and support.
Hi, everyone. My name is Vic Hannon. I live on a wheat farm in western Kansas. And I'd like to tell you a little bit about ourselves and what we've been doing so you can maybe relate to how important this is to us.
Sir, can I get your address, your mailing
My address is 14202 59th Avenue, Haviland, Haviland, Kansas.
Thank you.
Before 2002, my wife and I bought some land in Kansas at a farm next to where I was raised. And we decided that we would like to move there someday. And so we decided we had 3.5 acres, and that's a lot to mow. But I love the area. I assume you've all been there. That's a nice area there. And so we decided that we would like to keep 1.5 acres to build a house there in the future. And that's kind of where we were at. At the time, I was in 2002, I was 50 years old. We have 6 children, and we had 1 living at home at the time. Today, we have 3 of our 6 children living in the Lincoln area, and we have 6 young grandchildren in the Lincoln area. So we would like to move back with our children. So that's why we started the project with Brian Karsten and Associates, who used to be around, or I don't know if they still are around, and then Mark Hunziker at the time. I would also like to mention on the Planning Commission, when I was up here in 2003, 10 years ago, I'd like to just read what was written down, and my take on it is that they talked about a common easement, access easement with the church at the time of the widening of Pine Lake Road. And they think the city should be flexible and work with the new property owners in every way possible. They believe this seems like a good alternative. The widening of Pine Lake Road was believed at that time to happen in 2 to 4 years. I want you to keep that in mind because as I go on in this, and I don't have much more to say, but I want you to know this has been a long and expensive process to gain access to our property. I honestly believed for 16 years that at the time of the widening of Pine Lake Road, we would be allowed access to our property. I mean, please put yourself in my shoes as you're hearing these comments. And I have kind of two questions. You don't need to answer them, but I'd just like to say them. And it kind of, one of my frustrations for 16 years, I paid approximately $1,400 a year taxes on that property. I have called and talked to them, and they never got any reduction on that, and that can be checked. And the lot has been valued at about $70,000 all this time. So I've been paying $1,400 average a year for I believe 16 years. The new valuation says it's $80,000, and so the taxes are going to go up. I mean, imagine if you owned something. I mean, I guess I'm just kind of at wit's end on that the only way I could get it mowed was to have someone that would either park his truck on the street or drop his mower off and get on there illegally, because otherwise we have to use the church lot to get on it. I mean, but we have cared and mowed our property for 16 years, and proud of the way that it looks. In 2002 or 2003, we paid $5,500 for a future fire plug on this property. There's no future fire plug on the property. That's part of what I was talking about, is that this has been a long and lengthy and expensive process, and it's very frustrating to me. And I guess again, when Kathy and I started this, I was 50, and today I'm 67 years old. That's, a lot of my life. And we'd like to be able to build our retirement home on that property, and it would be a nice home. And I guess myself, looking back for the city's benefit, just imagine had there been a house on that property for the last 16 years, of the amount of taxes that the city would have been provided on that. Anyway, I thank you for listening to me, and I'd like to ask you to move in favor of this. And when we do get to build our home, come drink some tea with us. Thank you.
Questions?
Yep.
Any questions?
No.
No. Okay, thank you very much.
Yeah, thank you.
Do we have other testimony in support? Testimony in opposition? Staff questions? I'm sure we have staff questions. Staff questions? Go for it.
Brian, on the drawing that we have on our site that talks about all the improvements that are happening on Pine Lake with the roundabout and those access lanes? Can we talk about stuff like that if it's not in our packet?
You talk about what, yeah, I'm not quite following you. What
Okay,
exhibit is that?
so if you look at my computer,
Oh,
you know, how
Yeah.
that is defined for
Yep.
how things were going to be done.
yep.
Is the road then that's to the church right now, and how that is being developed with the right in, right out, and the parts that are designed by the city? So if they say they'll pay for it on their property, and then in the future, the church can add on with that, could that be part of it?
Part of that exhibit you have there?
Right.
That's a question for Public Works. I mean, that is an exhibit of
Right.
the design improvements for public road. That's done. That's been built.
It's been built? Okay.
Yep.
Yes.
And Commissioner Joy, could you just clarify what exactly you're looking at there for the purposes of creating
You bet.
somewhat of a clear record?
Though it is the definition of the improvements as defined back in 2017 through 18, and then the updates in April of 2019. That's on our website for how those improvements are being addressed from a city standpoint
For that
with the
For
roundabout.
that section of Pine Lake.
Yeah.
Road.
And that's on the city's website, is that what you're telling me, Commissioner Joy?
Correct. So if you
Okay.
look at transportation and utility projects,
Okay.
and then you look at the project highlights for Pine Lake from 61st Street to Highway 2, the widening and safety improvement project. And then there's different PDFs that attach to that based on standards that we should be following.
Okay, that's
And-
fine.
Okay.
Yeah, I just wanted to be able to make sure that we put that in the record somehow.
Do
Thank
you want Christie to, Commissioner Joy, to email a link to Jerry for that? For the
I
record?
think based on what I've been told, I think I
Okay.
can find it, but thank you.
Perfect, that's great. And so I guess my question is, so what you're saying is the concrete's already poured and it's too late?
Yeah, the road's built. Excuse me. Yes.
Go ahead, Maya.
Brian, what do you say to the argument that has been made that it couldn't have been anticipated, that it would be so difficult to reach an agreement with the neighbor, and that the Pine Lake project would take as long as it has? Or in your experience, or is there anything out of the ordinary, or do you see this on a regular basis in your day-to-day
Oh, yeah, I
life?
mean, this question comes up routinely, I mean, repeatedly. And that's why, going back to the original discussions on this property, subdividing it, that's why this was the number one main point of discussion. This was the issue to be resolved, and it was talked about at the public hearing. It was stated in the staff reports. By the way, so I'd just like to make sure it's clear that we're talking about the planning commission, their approval, and then it went to city council and their approval. The exact language of that amendment, city council, was provided that owners provide the necessary easement and consolidate the access to Lot 2, Hannon Addition, with the existing access to Lot 1, Country Place 22nd, that's the church lot, to the east of Lot 2, Hannon Addition, and agree that access provided to Lot 2, Hannon Addition, be restricted to an access for one single-family dwelling. It mentions nothing about timing of Pine Lake Road or when Pine Lake Road is going to, it had nothing to do with that. Now, the planning commission tried to tie it to that, but that was stricken and replaced with this. The only place in the record I can find that somebody mentioned 2 to 4 time frame for improving Pine Lake Road, because it was not in the capital improvements program, which goes out 6 years, was by the applicant's representative at that time. The city made
Isn't that what they're trying to do now, though? The condition, isn't that what they're trying to do, and the church is kind of stonewalling?
I'm sorry, I don't follow that.
The access, connect to the church access.
Well, no, what this applicant is saying, give us a new driveway.
But they went to the church and asked the church.
That's what the applicant has stated, yes.
Yeah.
And the applicant
church
is,
said no, because of liability issues.
yes, the applicant approached the church to be able to share their driveway, consistent with this condition of approval, but the church apparently said no. So the recommendation in 2003 would have been, stop. It's not going to work then. Well, if we're going to talk about the motion to amend, I do have a comment on that. So the changes, in my view, I mean, they're not major changes. It's just that we wrote these setting it up for a community unit plan and then a final plat to follow. And the reason we're saying, and we included the requirement for the final plat, is because building and safety will not issue a building permit on this parcel or on this portion of the lot, that's two dwellings on one lot, without a final plat.
Brian, is it even possible to have an address assigned to this lot without?
They assign addresses at the time of final
Right.
plat.
Okay,
In a case like this, so
so I thought.
they would not issue an address, would not issue building permits.
Right.
So Brian, I just want to make sure that I'm understanding correctly. Staff does not support the motion to amend.
Yeah, none of these that are stricken or changing, right, we don't support any of them because we're still saying, even if this gets approved, we're still saying these are necessary conditions that need to be applied for when the final plat comes in.
Right.
It'll be a two-lot subdivision, lot 1, lot 2, which is condition 1.1.1, correct the lot numbering. This would be lot 2. Show the private roadway and an outlot. Well, it's just conventional community unit plan. If you're going to have a private roadway, shared access, that'll be in an outlot. We've learned over decades of doing private roadways and easements and other things that that's the way to do it. And so that's why we're setting it up so that if our recommendation to deny is overturned, that these conditions can then be applied so they can follow through with a final plat that works and would allow this to get a building permit to develop it.
Other questions for staff?
Yes.
Yes, Tom?
How does the owner legally gain access to the condominium?
I'm sorry, this owner,
Correct.
I can't tell you that.
So.
How does this owner get access back to South 66, having sold off
Today.
that interest in the
Yes, today.
I don't know, that'd be a
How do they
question
get access
for,
to a public street?
that'd be a question for some attorney. I don't know, I can't tell you that. I don't know the terms of the condominium regime. I don't know what the provisions of it, I don't know what it.
It seems as though in 2003 that the city council approved a condominium regime that provided for no access.
The city council did not approve a condominium regime. This is an action wholly on the part of the applicant.
Okay.
That's right, a city council wouldn't have any role in approving a
Because
condominium regime. A condominium regime is really a way to
Done
subdivide
independent, yeah.
property privately without the involvement of planning department, city council, planning commission. All of those processes go out the window because you're subdividing privately.
Sure. The city allows for it. So, yes.
Yeah.
So, in the process of, let's say, this owner mowing their yard, Tim,
Mm-hmm.
how would they go about that?
I don't have a good answer for you on that, Commissioner
Sure.
Beckius. I mean, the access to this lot is from 66th Street. The city hasn't deprived lot,
Access.
whatever it is, Hannon,
Correct.
or lot, whatever it is of Country Place, because I think that's the final plat we're under. Hannon Addition was never
It's
approved.
a failed final plat.
It's
It was
a final
approved,
plat
but-
that doesn't exist.
But died, right, it expired because of
Right.
timeframe.
Right.
And just to clarify, the action before the city council, where this motion to amend was considered and was approved ultimately, was an action to to release the relinquishment of access. So that was the decision before the city council. That needed to happen in order for the final plat, for the administrative final plat to be approved at that time. So the very question in front of city council at the time that this was taken up in 2003 was, should this Lot 2 proposed Lot 2 Hannon addition be given access back to Pine Lake Road? And the conditions are what it has been shown there, but without any reference as a result of the motion to amend to improvements to Pine Lake Road.
Okay.
Great.
What would it take to get access to 66th Street?
It's going back through the portion of the regime that was sold. I don't know. An agreement between the two parties, I assume.
So
Yeah.
either way, there needs to be negotiation with another entity.
With one of the two entities involved. Correct.
Any other questions?
No.
Okay, thank you very much. Do we have applicant rebuttal?
First, I would say, the first item would be that while it's been stated that private roads are done in an outlot, I think a private roadway, and while that is a way to do it, while that is the typical way to do it, they can be done by other methods, and that's what we're proposing here. Also, that we would ask that even if you do decide to include, to approve with conditions of approval that require subdivision, that you would also approve, and it makes the most sense to have approval with the condition for approval of the request for deviation. And finally, I just would like to note that we have talked to every neighbor that we can. We have tried to bring in every city department that we can, and tried every solution that we could before we came here in front of you today. This has been a long process with many different options tried, and now we're here before you today. So we're asking that you consider this, and please support this CUP that's in front of you today. Thank you.
Thanks.
And I'm not sure if you're gonna know the answer to this, but do you know who advised your client to create this condominium regime, or why they went that way in the first place?
As I talked about, my understanding of this was that it was the best option at the time. My understanding is that the lot with the house on it, that portion of the lot was already under contract to sell, and that this was the option to go forward to sell that piece of the lot and retain as required under that contract. That's my understanding of it. I wasn't there at the time, and that's where I'm with my understanding. I can't confirm that that is the case.
Other questions? Thanks. Okay, we're ready to entertain a motion.
Move denial or
Second, Beckius.
Discussion?
I just don't feel confident that the right communication has happened with the owner of the church property. And so I feel that attorneys in their magic ways have ways to track down owners and find contacts and that kind of stuff that the average layperson doesn't. And I would like to see more outreach to the church property owners and make sure that they really understand what's going on here, because I just don't really feel comfortable that that's happened yet.
I'm disappointed in a lot of ways. I'm disappointed it's taken this long and that it keeps coming back to us. But I agree with you, Tracy. The church is the key to this. If we're gonna get anything accomplished, the church has to agree, and there's no assurances. And I don't feel that maybe enough effort has been made to reach the national. So.
I'll vote for the denial because I think that the applicant was fully aware all along of their relinquishment of access to Pine Lake Road. I think that the failed subdivide of the parcel in 2003 should have illustrated to them that this was going to be an uphill battle from the start. The creation of the condominium regime, I think, was probably an effort to see what could happen. I don't think that the church is under any obligation to be a nice neighbor. It's great if they want to be, but they're under no obligation to be a nice neighbor. I don't know that the applicant has shown to me specifically that this would be anything but the proposed outcome that they would have been expecting for the last 15 years. I think the city has done a fair job of communicating that with the applicant for the past 15, 16 years. The flip side of that is we're talking about one single family property, a low volume count. We're talking about a stub that maybe could have been a discussion that could have been had, because we've known that this was a potential problem since 2003, although, yes, a problem of the applicant's own doing. So ultimately, I'll vote in support of denial.
I am also going to support the denial. I think sometimes, when we have to make these decisions, it feels really cruel, because we hear and acknowledge what you're going through, and what and in a way I'm sure all of us would like to accommodate, but there's a general best practices policy when it comes to planning that to make exceptions to policies that affect everybody, you have to demonstrate a real hardship. And I've been kind of listening for and looking for that exceptional hardship. And generally, if that hardship is of your own creation, it doesn't, it just doesn't hold as much weight. And I'm going to have to, just in the grander scheme of things, in a system where we all have to play by the rules, I'm going to have to stick to the rules on this one, even though I do appreciate where you're coming from.
And unfortunately, I'll be supporting denial also for the similar reasons that my fellow commissioners has stated. But again, it is very hard to do that, and but our staff has it's a lot about timing, and the due diligence of the staff is appreciated.
I'm going to also support support the motion for denial. I think this is a very unfortunate situation. I'm very sympathetic to what you are dealing with. You have a lot that doesn't have an address, can't be built on, and has no access to a public street. That's a really horrible thing. I believe Maya implied this. I believe in the integrity of, in this case, the policy of the access management principles that we have in our city. I think that's really critical to maintain that integrity, and it's really hard for me to support anything that would break that or affect that in any way for a lot of reasons. The outcome that you're dealing with, that we're trying to figure out here, is, as Tom said, it is exactly the same as it was 15 years ago. Nothing has changed. The solution continues and will continue to be in the future a solution that has to involve the church or the adjacent owner of the property to the west. There is no other way to resolve this. I believe maybe as much communication as you can possibly have with the church has happened, we don't have any advice for how you deal with that, but that's really what has to happen, is some resolution with the church to figure out how to share access, because that's the way out of this. So I think I'm hearing agreement here, so I think we're ready to vote.
Okay, this is for the denial of special permit 19025. Beckius?
Yes.
Finnegan?
Yes.
Harris?
Yes.
Joy?
Yes.
Core?
Yes.
Shear.
Yes.
Motion carried, 6-0.
Okay, I believe Christie wants to make
Yes.
an announcement.
Yes, please. I was just going to announce that we have our open house tomorrow night at 5:30 for our working group with confined animal facility operations. So if anyone would like to attend, we'll be having that. I'll be representing the commissioners, and we'll be looking forward to the public's comments on that. It will be at Scott Middle School at 6600 Pine Lake. And so, you want to go ahead and finish up for me, please?
That's our
Steve?
last application. 22nd in Pine Lake Road, Scott Middle School.
Thank you.
Oh.
Thank you,
At
thank you,
5:30 to 7, taking public comments on the first public comment draft that's been released on that. So thank you. That's a good reminder to us
Perfect.
to announce that, because we'd
Can
love
you
to have.
tell us, is that an open house format or is that a,
That is a public comment format. Our working group will be there to listen to the comments. We'll have a brief introduction, one little bit of business for the working group, and then it is there just to take them in the order people sign up.
can't be there right at the start time, they should still come?
Oh,
Please come.
yes.
And
Yeah,
yep.
I will say, though, we need to be out of the school by 7:30. So at some point, we're just going to have to wrap up comments. But that's really the first step in our process. It would later then be going to Planning Commission and then County Board. So if people miss this opportunity, they can always send us comments in writing. And then there's to be 2 other public steps as well.
Very good. I probably do need to say this, that at this time, anyone wishing to speak on an item not on the agenda may do so. I do not see anyone, so we're adjourned. Thank you.
Thank you. Hey, Brian.